Okay, we had a request from Ginger to speak. You have time. Thank you.
Thank you for the opportunity to speak on behalf of formally over 300 of your constituents tonight. I just had a question whether or not any of you had a chance to read thoroughly the public record, both the testimony as well as everything in this binder. Has anyone had a chance to do that?
Been reading it. I don't know if I read it all, but
Well, I had a chance to do that and I indexed it. So we've now had one informational meeting, one public hearing, and the results of the survey have come back. 195 for, 137 against, and 41 undecided. Rob, we saw your comment in the newspaper about it being even. And frankly, we don't know how you can take the group of undecideds and place them in the group of in favor of the project and then call it about even. That just doesn't really make sense to us.
I don't know if I said even, did
Yeah.
I? Now, that's what you read, but
So in any general poll, a closing lead of 15 percentage points is considered a landslide, and that's what this project opposition had from our perspective. We don't think that this record supports Invenergy's claims that the evidence is clearly in support of the project. The 200+ letters that were referenced by Invenergy in the newspaper, when you go through this record, they're form letters with many, many illegible scribbled signatures, many out-of-town construction workers, many duplicated records as well, people speaking 2 and 3 times on the issue. Letters with no signatures, no addresses. In all, giving the benefit of the doubt to a lot of them that I really shouldn't have given the benefit of the doubt to, 105 Farmersville residents stated support for the project. And of that, 46 of them have leases, so that's about half. The Farmersville population of 126 alone beats that. When you look at the total communication points from people in opposition to the project in this record, the total against was 211. That includes the Amish. So since Invenergy's counting on non-Farmersville people in this numbers game, I thought it's important that you know that last week the town of Franklinville retained us to represent their 3,000 residents. The board there is adamantly opposed to this project. They want to fight it all the way. Those are your actual neighbors, not out-of-town construction workers. You know, that's really, we're talking people that are right there being impacted by the project. We expect other local towns are going to join this week and next. So I think, from the perspective of Invenergy's claim in their application, that at least in this part of the town, in this corner of the world, their claim that there's vast community support for this project is just simply not true. It's just simply not true. In fact, they said for Farmersville, it's a small minority of people fighting this project, and I think that's false. So all of these people here tonight, at least a good portion of them, probably some of them are pro-project, and that's okay. We're calling on you to give us a stronger wind law. This includes what we've been asking for all along: 3,000-foot setbacks to property lines, 40 decibel, 24/7, 365 at the property lines. And since many people in the public record wrote favorably about the Eagle and Bliss wind turbines, said they weren't noisy, said they were less of an eyesore, that they don't kill birds or bats, we'd like ones like those too. What are they, 450 feet? That's what we would like. None of our members want to hear, but this will kill the project. And we certainly don't want to see the board again ask Invenergy, like it did at the last wind law session, are you okay with these changes? This is not a wind law for a specific project. Or is it? Invenergy does not care about any of us. They're just maximizing their profits. I understand that. That's what corporations do. I work for them too. Invenergy doesn't care about any of us, really. They're just out there doing what they do. The board doesn't have a constitutional duty to Invenergy, but you do have a constitutional duty to all of the people in this room. And putting in a reckless wind law is not fulfilling that duty to us. Well, you say, well, how is that reckless? Notably, Invenergy was just told by the New York State Siting Board in another project to perform evaluations of long-term potential cardiovascular impact and cardiovascular disease for a threshold of 50 dBA. Long-term in that parlance is 1 year. They were also asked to do an evaluation of conformance with the new 2018 sound recommendations, which is 45 dBA. Why is our proposed law over this? Why are we considering a level of dBAs that have yet to be studied for the health impacts? That deficiency letter should be in your mailboxes right about now. I think we'd like another work session, and we would like the residents to be actively involved in conveying to you our thought processes on these. And that's why you can see a lot of people here tonight showing up for this, because we're concerned about the direction that this is going in. And that's
Okay.
what we'd like to bring to you tonight.
Thank you.
Can I ask one question?
Everybody be stand for the pledge. Pledge allegiance to the flag
of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, the first part of tonight's meeting is public hearing. Do the public hearing, then we'll do the reorganizational meeting, and then our regular board meeting. So at this time, I would like to start out with Dave, you want to?
You have the notice of public hearing of the public. Thank you. Notice of public hearing, Town of Farmersville, a local law providing for the defense of the Town of Farmersville's officers, employees, and certain volunteers. Notice is hereby given that a public hearing on a proposed local law which provides for the defense of the Town of Farmersville officers, employees, and certain volunteers will be held on the 14th day of January 2019 at 7 p.m. in the Town Building of the Town of Farmersville. This is a public hearing, is being held to hear all interested parties and citizens for or against the adoption of said local law. A copy of the proposed local law is available for review at the town clerk's office during regular business hours by order of the board, Bridget Holmes, town clerk. And that was published in the Olean Times, and I believe that was published on 12/27/2018. It was also published in the Arcade Herald, I think relatively the same date. We don't really have an affidavit of publication.
For the Olean Times Herald, I do. Alle-Catt Herald does not.
Okay. And what was the date of publication
Let
then?
me. That's the reorganization. December 28th.
Yeah, that's what it appears here to be all the same. Did you want me to read the entire law?
Well, it probably should, right?
Okay. Section 1, as used in this local law unless the context otherwise requires, the term employee shall mean any member of the town board, town officer, town employee, town volunteer expressly authorized by the town to participate in a publicly sponsored volunteer program, or any other person holding a town position by election, appointment, or employment in the service of the town, whether or not compensated, but shall not include an independent contractor. The term employee shall include former employee of the town, his or her estate, or judicially appointed personal representative. The term town shall mean the town of Farmersville. Section 2. Upon compliance by the employee with the provisions of Section 3 of this local law, the town shall provide for defense of the employee in any civil action or proceeding in any state or federal court arising out of any alleged act or omission which occurred or is alleged in the complaint to have occurred while the employee was acting or in good faith purporting to act within the scope of his or her public employment or duties, including without limitation any civil action or proceeding arising out of any alleged act or omission which is alleged that the officer or employee has violated the civil rights of the claimant, petitioner, or plaintiffs under 1981 and 1983 of the United States Civil Rights Act, 42 USC, Section 1981 and 1983. Such defense shall not be provided where such action or proceeding is brought by or on behalf of the town. Subsection B. Subject to the conditions set forth in this local law, the employee shall be represented by the town attorney or attorney employed by or retained by the town for the defense of such employee. The town board of the town shall employ or retain an attorney for such defense of the employee whenever, 1, the town does not have a town attorney, 2, the town board of the town determines that based upon its investigation and review of the facts and circumstances of the case, that the representation by the town attorney would be inappropriate. Number 3, a court of competent jurisdiction determines that a conflict of interest exists and that the employee cannot be represented by the town attorney. Reasonable attorney's fees and litigation expenses shall be paid by the town to such attorney employed or retained from time to time during the pendency of the civil action or proceeding, subject to certification by the supervisor that the employee is entitled to representation under the terms and conditions of this local law. Excuse me. Payment of such fees and expenses shall be made in the same manner as payment of other claims and expenses of the town. Any dispute with respect to representation of multiple employees by the town attorney or by an attorney employed or retained for such purposes, or with respect to the amount of fees and expenses, shall be resolved by the court. Subsection C, where the employee delivers process and requests defense to the town attorney or the supervisor as required by subsection 3 of this local law, the town attorney or the supervisor, as the case may be, shall take the necessary steps, including the retention of attorney under the terms and conditions provided in subparagraph B of this section, on behalf of the employee to avoid entry of a default judgment pending resolution of any question relating to the obligation of the town to provide defense. Subject to conditions set forth in this local, the town shall indemnify and save harmless the employee in the amount of any judgment obtained against such employee in any state or federal court, or in an amount of any settlement of claim, provided that the act or omissions from which such judgment or claim arose occurred while the employee was acting within the scope of his or her public employment duties, provided further that the case of the settlement, the duty to indemnify and save harmless, shall be conditioned upon approval of the amount of settlement by the town board of the town. Second paragraph of subsection D. The duty to indemnify and save harmless prescribed in the subdivision shall not arise where the injury or damage resulted from criminal acts, intentional wrongdoing, fines or penalties, or money recovered from an employee pursuant to section 51 of the general municipal law. Provided, however, the town shall indemnify and save harmless its employees in the amount of any cost, attorney's fees, and damage, fines, and penalties which may be imposed by reason of an adjudication that an employee acting within the scope of his or her public employment or duties has, without willfulness or intent on his part or her part, violated a prior order, judgment, consent, decree, or stipulation of settlement entered in a court of this state or the United States. Section 3, duties to defend provided this local law shall be contingent upon 1, delivery of the town attorney, or if none, the supervisor, the original copy of any summons, complaint, process, notice, demand, or pleadings within 5 days after he or she has been served. Full cooperation of the employee in the defense of such action or proceeding and defense of any action or proceeding against the town based upon the same act or omission and in the prosecution of any appeal. Such delivery shall be deemed a request by the employee that the town provide his or her defense pursuant to this local law, unless the employee shall state in writing the defense is not requested. B, the duty to indemnify and save harmless prescribed by this law shall be conditioned upon full cooperation of the employee in the defense of such action or proceeding and in the defense of any action or proceeding against the town based upon the same act or omission in any prosecution of any appeal. Upon entry of a final judgment against the employee and upon the settlement of any claim, the employer shall serve a copy of such judgment or settlement personally or by certified copy, registered mail, within 30 days of the date of the entry upon the supervisor of the town. If not inconsistent with the provisions of this section, the amount of such judgment or settlement shall be paid by the town. Give me 1 second.
Careful with that.
Section 4, the benefits of this local law will inure only to employees as defined herein and shall not enlarge or diminish the rights of any other party, nor shall any provision of this local law be construed to affect or alter or repeal workers' compensation law. Section 5, the provision of this local law shall not be construed to impair, alter, or limit or modify the rights and obligations of any insurer under the policy of insurance. Section 6, as otherwise specifically provided in this local law, the provisions of this local law shall not be construed in any way impair, alter, modify, abrogate, or restrict any immunity available to or conferred upon any unit, entity, officer, employee of the town, or any right to defense provided for any governmental officer or employee by or in accordance with or by reason of any other provision of state or federal statutory or common law. Section 7, the provisions of this local law shall apply to all actions or proceedings specified herein, which have been commenced, instituted, or brought after the effective date of this local law. This law shall take effect upon filing with the Secretary of State. That's complete law.
Thank you. Any questions?
So then I think you need to make a motion to open the public hearing.
Okay. Do I have that motion?
I'll make a motion to open the public.
Motion by AJ, second
I'll second
by
it.
Pam, all in favor?
Aye.
Carried. Okay, any questions, anybody?
How are you taking speakers?
You can be first.
I can be first.
You can be
As
first.
long as we keep it calm, cool, and collective.
I think generally I don't have a problem with people getting a defense, obviously, given what I do for a living, and I honestly do think that none of you get paid enough to have to put yourselves at risk. I think what I'm concerned about in this particular circumstance is the optics and the timing of this, and kind of how it appears to all of the people here, first and foremost. Second, I'm also concerned with the omission of the word reckless, which is clearly called out in section 18 of the Public Officers Law. In section 18(4)(b), it says, except as otherwise provided, the duty to indemnify, save, hold harmless, shall not arise where the injury or damage comes from the intentional wrongdoing or recklessness of the employee. And yet in our law, what I saw is that the duty to indemnify or hold harmless was called out to not apply in criminal acts, intentional wrongdoing, and in fines and penalties. So I do think recklessness should be added back in there. That's my only comment.
Anybody else?
I have one question. Is it a gap, the top ceiling, how much you will pay for the defense? And where the money will come from?
Where all your money comes from the general fund, from, if you're a taxpayer, from you, sir. That's where the money would come from. They do have insurance, and to some extent, this was just to make sure that we were complying with the terms of our insurance. So there is insurance available for this type of act as well. But we are paying a premium for it.
We'd use that first.
Hopefully we use that for the whole
Yeah.
thing, but
Correct.
hopefully we're on top of it to make sure that we're watching it so that it doesn't get to be that kind of money, that it exceeds our insurance policy.
But you should give your name for the record.
I'm sorry, Greg Cartier.
Karcher?
Cartier.
Ginger, you don't need to give your name.
Do you know my name?
We know your name.
My name's
Thank
Tim
you.
Jones, and I guess my only concern with it is that if it is found that it's reckless behavior, will the person that was being represented, would he have to go back and pay out of his pocket for it? I mean, my tax dollars paying for somebody, and then it is somebody's wrongdoing, he should have to be accountable for paying back for the lawyer fees.
Can I tell you where I've used this before, and just, because again, I've never used it too many times, except once, okay? And it was a town judge, and they sued her personally for a decision she made.
Mhm.
And, I mean, the way it comes to you when you see it, bottom line is you get the service and the judge reaches out and says, here, I got these papers. Typically, the town board sits down and says, what was this all about, And so very early on, you have an idea of what they're being sued for. Is it a criminal act? Was it, was there like an intent to hurt somebody? And, typically, as you see it proceed down, hard to sit here in a vacuum and know what every possible,
Right, scenario.
but when it comes in the door, and you get a summons and complaint, and you're reading the various allegations, you really quickly understand whether it should be something covered or it shouldn't be something covered, i.e. somebody got paid $200,000 on something out the back door. No, we're not covering you. But if it's, a judge making a decision that somebody didn't like and they sued her personally for it, yeah, that's what judges do, is make decisions. Typically, one side's not gonna like it and the other side might like it.
Sure, but I'm just trying to make sure that
Good question.
nothing's gonna be abused by it, because
Right.
it's not just the board members we're talking about all employees.
You think
And there's a
about,
broad.
and whoever
Right.
thinks about a judge getting sued.
Right. I understand.
But that was
It's-
the only case that I've ever seen where an employee, someone of the town's gotten sued for an act.
I have a question. Do you take an oath to look after the health, safety, and welfare of the citizens as town board members from the New York State Constitution?
Every elected official is required to do an oath. I don't know that our employees are required to
No.
sign an oath.
Looked at.
And if they did wittingly, after finding out certain information, somehow hurt the health, safety, and welfare of their constituents, would they be, we have to pay for their hurting us through our taxes, getting from all this?
Again, depending on the fact pattern, you might have to some extent, pay for the defense. But again, it's all gonna be dependent on the fact pattern.
It must be something that's starting getting more common because the fire district got a letter
From the insurance
recommending,
company?
recommending that the fire district do the same thing with the resolution this week.
Well, to be honest with you, everybody agrees that there should be some indemnification for anybody that's in a public position. Everybody understands that. We're just, I guess my point of view is, you know, there's no elected official that takes any advantage of them
Right.
situations
Oh, I
as
agree with
there
that.
is. And, you know, I guess that's where everybody's concern here is we don't wanna see.
Well, I
any of
think
that.
too, if the insurance company doesn't cover it, I mean, they might have something to play in with it too, so if they have a reason not to approve it, I would think we would have to do the same thing or look into it deeper. That's my opinion.
Are all of you required by law to have read everything that we presented to you? Paperwork, articles, anything that was delivered to this office
Is-
before, I forget what the exact date was.
As far as like for the wind project,
Yeah,
I don't know if it's required by law, but it's our best interest to do that.
because how can you know that you're not hurting our health, welfare, and safety if you haven't read what's been
Well,
presented to you personally?
We've
How
been,
could we even sue you if you don't know what we're suing you for?
yeah, that's a good point.
Thank you.
Anybody else? Lois?
Well, my question is, you said something about in their powers of their duties and what they're required to do as a town board. Now, is it acceptable if the town board takes a person's property and allows somebody else to use it? Is that part of their rights to do?
Well, again, there are eminent domain proceedings, okay? But if, again, they're answerable for wrongs. If you think the town's taken property or and again, it would be the town, if your question's from a town perspective. If the highway superintendent took part of your road, you would sue the highway superintendent and you would sue the town and we would defend him, okay? If we found that, you know, he took part of the road and maybe put a tree stand there and boxed it off and was feeding his deer there, you know, we might have a problem. But again, it's all gonna be factually dependent.
Well, if the property is not the town's and they take it and don't compensate for it or allow somebody else to use it, is that legal?
Again, I don't know all the facts, and I think you're probably in a very specific manner that I don't know about. So I understand what you're asking, but I don't know enough about it.
And they decided to take it over and have a resolution to allow somebody else to use it as a public road. So now I'm thinking, okay, now I hope the town board and the town highway decide that they're gonna start maintaining that road and that they're going to take a liability off of us and then compensate us for the property.
As far as I know, what you're talking about, that was all taken care of.
It's
Like
not-
that
We haven't
close?
been paid for it. We have not been paid for you stealing our property.
Well, we
That's
didn't
not
steal the
justice.
property.
And you only did
We're
it to
not
cover your
discussing
wife's
it no
butt
more.
because she made the wrong
Guys,
decision for
okay,
it.
I
let's
was
just
shutting it down.
real quickly, the other part of this is though, if you believe you've been wrong, you know, you are always invited. There's a courtroom in every county, there's a state Supreme Court, you're always invited to bring action, okay?
We did, and this beautiful lady over here, she decided to hoodwink the judge as to, oh, the road had never been abandoned,
Okay, we're getting off topic.
So
Lois.
therefore-
But again, what we're talking
but it was
about is.
never a road.
We're
It
talking
was
about,
not, it was our burden of proof to prove it was abandoned, her burden of proof to prove it was a road, and she didn't do that.
Hey, I'm shutting, Lois, no more on this. If you got to go
I
to the
know, we
county
were supposed
court,
to discuss it when you did the resolution right from the get-go, and it was
and we
our
did,
litigation
we had a
we were in.
public hearing on that, and this is on a different topic. I understand what you're trying to
It's
say.
still something the town board has done wrongfully to us.
Well, it's closed, we're not talking no more about it tonight. Thank you.
Okay,
Anybody else
can I have a
on
copy of that,
topic?
Tom?
Yes,
Can I
sir.
have a copy? Thank you.
I'm sorry.
Representation was not given to you before, or?
Thank you.
This presentation?
Yes.
No, sir.
So in other words, you are asking us to allow you to be a representative because you haven't been before?
I don't understand.
I don't understand your question. I'm sorry, and I didn't hear the first part of it, and I apologize for that.
This is about the law, then town will be, employees of the town will be represented by somebody appointed or retained. You mean before today, there was not available to you,
There was not a law
No.
requiring it, correct?
but it was available to you?
The law was available to be adopted, but it wasn't part of the record, sir.
Representation being available to the town board and people work for town.
It didn't have a procedure or required how the town was to deal with a lawsuit against the town employee. This basically delineates specifically when the town will defend a town employee and how they go about doing it.
So in other words, nothing's changed?
I don't know if I
Just
could
the
say
law?
anything's changed, but this specifies how you follow to make sure you get the indemnification and representation.
So that-
See, the problem is, you could sue a town employee and maybe get in judgment, and if they never provide us with the information, we don't know what's going on if you're not suing the
Right.
town board. This says, hey, look, if you want us, you bring that to us, you cooperate with us, and we'll work with you.
That leads me to the first of my question is there a gap on it? How much the town will be responsible for the representation?
It doesn't have a limit, sir.
So that's not really good, isn't it?
Well, I'd be honest with you, I think there isn't any gap now. You have an obligation. Highway superintendent's the perfect example. You're the guy with all the risk. He's out checking roads at night and wipes out something. You know, it could be catastrophic. You're right, the town's on the hook. If for some reason, you know, they bring it against him personally, you could see why we would indemnify him. Again, he's doing it on behalf of the town.
I understand this part is mostly accidental. I'm talking about intentional wrongdoing.
And what we told you about intentional wrongdoing, it's not covered.
We wouldn't approve it.
And recklessness should not.
Yeah,
Right.
and Ginger has said, Ms. Schroder said, no, look at recklessness too, and she's directed us to that, and I think probably the town board will make me look at that tonight, so.
Right. Well, I'm sorry, Kathy had her hand up there.
Um,
I'm sorry.
well, is it my understanding that the town board is already covered under statutes for this sort of thing as far as being somewhat immune to a lot of types of lawsuits that can come along? That's my understanding, and I was wondering if there is some kind of reference here to enabling statute that tells why or what power you're doing this in. Is it section 51 of municipal home rule or general municipal law?
Yes.
That's the whole thing.
Yeah. Well, the problem here, we're doing it under municipal home rule law, just so you know. The authority to do this is under municipal home rule law.
Okay.
Okay. And the reason why, again, is because there's gaps. Just like he said, there's gaps. We never know what we're gonna be sued for and what's gonna happen. This covers everything. Hopefully this covers everything. So if you were on a board, or if you were the assessor and you get sued, this makes sure that the representation is there.
But this is kind of like an extra added layer
Protect.
that what most towns go to the extent of doing. It reads to me just reading it like a layperson, I'm not a lawyer, but it reads to me like if, for example, you had a bookkeeper, not saying anybody's name or even, just an example, that someone stole money from the town. They thought it was theirs. They're willing to cooperate with you and tell you all the circumstances. They're found guilty. And this here says that even if they're found guilty, and there's a big sum of money that they have as a settlement, the town is gonna pay it off for them.
I'm not quite sure I understand the fact pattern. If you're suggesting, if I can just go back, typically a bookkeeper would be taking care of our money, right? So if there's money missing, it would probably be a criminal act, and we wouldn't be representing them because of the fact that they criminally done it. It was an intentional.
Is a criminal suit exempted from this law?
Yes.
Yes.
I have a question. How is it not reckless to not read information that is given to everyone that has to do with the health,
Okay.
wealth,
Yeah, hold on.
and safety
Your
of the
turn.
citizen? If they can't, if they're not privy to
So-
it, how do they know?
Go ahead.
I just wanted to know, are you saying that you hadn't had any coverage before now, or this is an additional?
It's an
It's an
additional.
additional.
It's an additional. We have an insurance binder. When you deal with your insurance man, the person, there's another thing that we're gonna do maybe next month, but it has to do with prior notice. I don't know if you recognize this, but I'm here an awful lot now. So I sort of justify there's these laws that we really should have on the books that we don't have. This is one of them.
Okay.
It's not any more than, that, if you have a Phillips head screwdriver and a regular screwdriver, then you have these are tools that should be in your toolbox. That's all.
Anybody else?
So if I can just say my final point
Please.
is that I think it's going too far, it's too much, and the taxpayers really don't want to pay settlements for people.
Can I suggest, though, why this is important and why that works better for you? This says that the minute you get that summons and complaint, you have to come back to us. You have to either come to me or come to the supervisor, and we become proactive, okay? If there's a settlement or something's going wrong, if it's in the name of an employee, we don't know about it until it's over.
Well, I don't understand why it would be a problem.
If they sued him and he decided not to tell us until there was a judgment, it would be a problem.
But I think it would be highly unlikely that anyone was
Okay.
sued by himself.
I don't dispute that, but what I would suggest to you, it's nice to have it in paper, so you can hand this to all your employees and say,
Right.
hey, look, when you get this, this is what you do.
And I don't begrudge anybody not having representation.
Yeah.
I just think there's things that cover you already.
Thank you.
Okay, anybody else?
Dave, isn't that just like an employee handbook though? Like, you get a lawsuit, you tell your supervisor, just have it in the handbook.
Yeah. If you get hurt, report it,
Right.
No, I get what you're saying, but if you get how do you make them cooperate then?
What do you mean?
Well,
You
one of
don't
the
have
other
a
things
job,
is you
don't
cooperate.
You don't follow the rules, you're out.
No, that's not the way it works. A lot of times.
I got a question. David Putney, why is this being introduced now? Because it's just the timing and all this.
It's all my fault. Just so you.
1 second, please.
Yep.
Like I said, why is this being introduced now? The timing of this entire thing seems strange that you're trying to cover up something that could be there's a lot going on in this town right now, that affects this town for years. And now all of a sudden you want to introduce this bill. Is there something going on the backside here? What are you trying to cover?
And if I could just, again, I'm here an awful lot more than I was. I've been here since August, okay? I've asked for a local law manual to look at what they had, okay? Because I need to know what's here, okay? And that probably took me till October. and then it's like, geez, you guys don't have this and you don't have that. I mean, it's like anything else, when you come someplace, you hopefully make it a little better than when
Yeah,
you,
but just
when you left.
With everything that's
I
going
understand,
on,
and I
it
agree
seems-
with.
With the timing of this, it just seems strange.
I agree with
So
you, and I
have to
agree with
ask-
Ginger, it's bad optics. I would have loved to adopted this several months ago before this was in this type of setting, so I'm not sitting in front of you. This law gets adopted 100 times in 100 communities with maybe one question. It doesn't have it sitting in front of a group of people like you,
But do the other 100 communities have the same thing going on, or what we do now?
typically.
I don't think so.
Dave, I can tell you, I was talking to other supervisors, I was talking about a supervisor and a couple of county clerks, and I said I had this local law, public hearing. And she looked at me and said, what do you mean? We have that for years. So it's not and as
Just
fire
curious.
district. I'm not
It
saying
is
you're
bad
saying,
optics.
I'm just saying it must be something because the lady looked at me like I had grown two heads.
Plus the fire company is
But
making you do it.
this is not the one under the public officers law. This is not, you're covered. You know, this goes farther. Sorry for talking out of turn on this.
You're fine, thank you very much for your comments.
Okay. Any discussion from the board?
Adding the word recklessness?
Well, we can look at that.
Yeah,
If I were, my suggestion to you guys,
Well, I still think it should be something that definitely should be put in there, not to bring up the highway superintendent.
You know, I understand, you know, it might change his views when he's driving the truck or the plow. You know, if you know, I hit that vehicle, if I get some bits, it's covered by, you know, I know I'm not saying that it's the way it is. I just, you know, try to keep a good grasp on what could happen outside of this here, the board.
Shouldn't have to hit a vehicle on the roads from November 1st to April 1st. And we need to do something about that because there's a lot of people that ignore that sign and that law.
I'm not, it's just using it for
I'm just
instance.
saying, but
I got a
that's-
long driveway I can park on. I'm just using it for instance,
We just get
right?
mixed up as.
I mean, I'm just trying to look outside
When
of
they're
just
done,
the
I'll
board
talk
members
for
and
you.
that the workers out here do while they're on the clock. That I know that we can say that it's criminal and that you guys are gonna be the ones to make that deciding factor that we're not covering it, or somebody says, yeah, we're gonna cover that, cause it's borderline. I mean, it's our tax dollars that we're putting in,
We understand.
you know.
Okay, Dave?
my suggestion is if you guys are gonna close the public hearing, you know, you've heard a lot here again tonight. I mean, none of it was nonsensical. It was all, you know, you should take some time to think about it. I would think, you know, Ginger Schroder suggested, look at reckless in 18.4B.
Right.
I think perfectly reasonable to look at that, and I'll bring it back to you next month. I mean, you're not required to pass this tonight, you're
think
required to
that's-
think about it.
I think that's
And I
a
think
good
it's
idea.
helpful to think about it, it's helpful to get comments, and you can chew on this a
There
little
is
bit.
no rush to get it done, so we need, you know, and I think that's good advice. Everybody in favor of that?
So how does that work? So we
Pose-
table it and then, or does not vote on it, I guess you don't table it, but, do we just discuss this? Like, when do we discuss this as a board as far as if we're gonna change it or not, or how do we do that? I know that.
Can I
That's it.
suggest what I would do is probably, I'll look at 18.4B and look at reckless, okay? And then issue you some type of letter in relation to that. I would assume next month you'd have you would have that letter as well as the resolution, either to adopt or to amend and adopt, whatever it is.
Right.
Or, and then you guys can say, we're not doing this, goodbye, good night, we're done, you know? Again, you don't have to pass this in the next 6 months. This thing can sit there and just gain weight, you know, and
Okay.
just sit. That, you know, once you finish the public hearing, you can come back to this at a later point in time when you're ready
That's
to
a good
move.
idea. You guys all in favor?
Just, and then
Yeah.
just sitting on the matter. Hey, can I just give you one other thing? Because
Okay.
again, I never want you to stop thinking about the law. The next one is a prior notice law, something else you don't have.
We could probably done
This is
that.
why people hate lawyers. And this, you're gonna like this. I had to do something for the highway superintendent so he comes back tomorrow. Okay, the prior notice law says this, look, we can't be sued as a town, okay? unless we have prior notice of a defect, okay? Whether it's let's say there's a bridge abutment down, or a hole in a road. You have to have prior notice of it. Prior notice is them coming to Bridget with a letter or a picture, and then if you'll see this law, it says once you get prior notice, then you're obligated to make a reasoned decision as to what you're gonna do with it. I mean, let's say that there's a defect with a bridge and it's gonna cost $250,000 to fix. You know, you're gonna have to have a reasoned elaboration why, one, I'm not fixing the bridge, and two, what I'm gonna do to make it as safe as possible. So it has a lot of reasons why you would want a prior notice law. Again, my friend Bridget and the problems I create for her, it does create an obligation for you, Bridget, to keep basically a log of notices that you've received, and then next to that log, you know, you giving it to whoever's in charge of that area of the town, and then what the reasoned response was as to, or we fixed it on the next day, you know what I'm saying? It could be anything.
Like written notice or a phone call?
Yeah, usually written notices. And we'll probably create a complaint log, something that you can have, so when somebody comes in here, just sign this here. You know, and then typically, it's interesting, there's some internet, notice type things about defects in town properties. And, they'll tell you about it and then what the town's doing to repair it and blah, blah, blah. Just something very good to have. You'll get the benefits of it in your insurance premium because they know you're being proactive. It's not anything that is gonna be strange to Farmersville. It's strange that you don't have it. It's something you should have.
Should have some kind of procedure too for like, if I'm gonna call Barry, hey Barry, there's a tree in the road. And Barry doesn't go pick it up for 2 days and somebody hits it. Well, there should be some log that Barry, some procedure internally that he informs people.
Yep.
It should be followed up through with their list taken care of or whatnot.
I just ask you to consider it. I don't know if you wanna have a public hearing next month on this. I've got a resolution, you can do that. Or if you just wanna take it home tonight, read it, come back next month. That's fine.
Okay. If there's nothing else on this,
Bridget, in case other people.
defense law, I would like to close the public hearing at this time. Have a motion to close. Motion by AJ, second by Richard. All in favor? Carried. Okay. Now we're gonna move on to the reorganizational meeting for the new year. I have a list of appointments. I'll read off. You still want to be my supervisor, right?
Yep.
Okay, Deputy Supervisor Andrew Warner. Deputy Clerk, first Sue Holmes, second Viola Brown. Deputy Highway Superintendent Ken King. Bookkeeper is Kathy and Jack Berry. Audit Committee is a town board. Town Attorney Dave D'Amato. Town Prosecutor Josh Frank. Assessor Kay Reynolds. Board of Assessment and Review. We have Denise Brennan, Heather Perkins, and we have an opening available. It's Thelma Mapes' position, but she said she would take it over if we didn't get nobody. So we did post it. We had no response, but we'll talk about that later on. Code Enforcement, Patrick Cummins. Registrar, Bridget Holmes. Deputy Registrar, Sue Holmes. Court Clerk, Sue Holmes. Town Constable, Court Security, Tim Chase. IT Specialist is also open at this time, and we'll discuss it later. Town Historian, Alice Wright. Custodian, Donald Purgel. Dog Control at Shared Services with Franklinville, Kay and Lonnie Farrington. Banks are Community Bank and New York Class. Authorized signatures, signees. Community in New York Class is Robert Karcher and Andrew Warner. Jack and Kathy Berry, online only for Jack and Kathy Berry. Community Bank is Robert Karcher and Bridget Holmes. Petty cash is $500. Procurement policy spending limits, $2,000, above $2,000 will need authorization and approval from the board. Mileage, 58 cents. Newspaper is Arcade Herald and Olean Times. Town board meetings will be held on the third Monday of each month. Work sessions are scheduled as needed. Payroll, bi-weekly, would be highway superintendent and highway employees. Monthly would be justice, town clerk, deputy town clerk, court clerk, bookkeeper, assessor, and code enforcement, and constable. Quarterly is the remainder of the list of the town board, and the town board. And that concludes,
I just want to make one correction.
Yes, sir.
Not that it'll be in the minutes, just the mileage was 54.5 cents, not 58. You just said 58.
oh,
We just increased
we
that,
just
that's a new
increased it.
limit.
Because that's the,
New cost.
that's
Mine
the,
doesn't have that on there.
Well, it was,
it was just. We usually
I
go by
pointed
the,
out before the meeting that the IRS had increased their mileage reimbursement for 2019 to 58 cents.
Oh, okay. So we're keeping it the
Sorry
IRS
about
rate.
that.
Sorry
Okay.
about that.
It was new for everybody.
Nobody put it on mine.
yeah.
Yeah, it was
58
happy to
cents.
get rid of the half cents.
Okay, anybody have any questions on this? Okay, I want to turn this over to the, well, you have a list, right, Rich?
I have a list.
Okay, I don't need to turn that over to you.
I
Yes,
believe.
Is that the current town prosecutor? Because I understand that there was no one that had left and there was a guy that was coming in or possibly coming in?
yes, this is
Is that
him.
the current one?
Yes,
Okay.
Josh,
That's coming in.
yeah.
Yeah.
Robert Strassel's no longer with us.
Oh,
Kathy?
he the prosecutor or the town attorney?
Dave is the town attorney and the windmill. He's our all attorney.
All right.
And,
Starting now.
pardon?
Starting now, right?
Yes. And, prosecutor is Josh Frank. He's starting right now too. Okay. If we don't have any other questions on that, I would like to close this part
I
of
need a
the.
motion to accept
Oh,
that.
that's right, we need a motion. Motion to accept the list.
I'll make a motion to accept.
Motion by AJ, second.
I'll second it.
Second by Richard, all in favor?
Aye.
Carried. Now we need a motion to close the reorganizational meeting.
I'll make a motion to close the reorganizational meeting.
Motion by Pam, second.
Second it.
Second by AJ, all in favor?
Aye.
Carried. Okay, now this opens up our regular board meeting. Moving right along. We're gonna start with the wind.
Public comment?
Usually I do public comment at the end.
Okay.
We'll start with the wind. Any wind discussion? Did you have anything?
I do have, yep. As you all know, we got a response from the Cattaraugus County Planning Board saying that our Part 1 was ambiguous. I don't know if it's ambiguous or conflicting, but that was the be-all and the end-all. Mark, who couldn't be here tonight, and I spoke, and we wanted to take the ambiguity out of Part 1 so that we could, I know it's important, I've heard you all speak to the fact that you wanted to hear what the county planning board's comment was on our law. I know that's something that, motivated you for a while, and it was something you wanted to see done. So this document, this Part 1, is the Part 1 that we completed the last time we were here, making the alterations in it, and putting it in final form. You want to look at, I don't know how far you want me to go through this with you, but it is the previous document, but with the changes that we came up with when we analyzed it. As I've told you, and you know I have a strong opinion about it, but understanding what your desire is, this part one typically isn't analyzed when you receive it. The analyzation of it comes after you go through parts 2 and 3. Typically, you send part one with whatever application you have to the county planning board at the earliest juncture. That's what 239L says, so you get the report. Because of the fact that they suggested they needed parts 2 and 3 before they would do their analyze this or move on it, we did do parts 2 and 3, and as a result of that, part 1 was, as I told you, was a working document, and we started working all over it. They took exception to that, so this is a part 1 that's refined. It doesn't show our work product on here. If you'll remember the last time we were here, there was quite a bit of discussion. We talked for a while. Mark led the discussion going through with only the precise and the way an engineer does things, and he went through this line by line with you. And this is a result of that discussion, and all of the changes to it are in accordance with that. If you want me to go through it line by line, I will, but this is what Mark...
We just removed the garble, more or less.
Well, I don't know if it's garble, and see, and that's where I differ with people.
Yeah.
I think it's sort of like, when I went to college, I thought I was gonna be an engineer, and I took differential equations. I never got one right answer the whole class, but I got a B. Never was able to answer the question right because you could show your work. And I equate that to any time I do anything with engineers or do a DEC document, show your work, you'll get partial credit. You might do pretty good in the class just by getting partial credit. My belief is that when you do an environmental assessment form, part 1 long form, you're to show your work. So it can show that you had a learned thought and you were thinking about this. You caught the mistakes of the applicant, you changed it, because you were thinking about this. And again, last time I was here, I sat and watched you guys think about this.
Right.
I know you've thought about this, and that's what this was. So basically, this would be a resolution, number 1, adopting this part 1, if you will, making the changes, and then number 2, a resolution referring it back to the county planning board, if that's what you do. I know we have differing opinions, but my thought is the gist of what I've gotten from you is you really want to know what the county planning board is thinking. You want to hear their recommendation.
Well, it seems though we went through it before and the answers are all the same.
Except, well, there were some changes, because remember,
there
was a change about the master plan, and we have a master plan. We don't have a master plan, okay? And that was one of, I think there was a change about school districts, right? I don't think we caught all the school districts the last time. I think Mark's caught them all in here this time.
Okay.
Those are the 2 big things, I think.
Well, if we go over the changes, I don't think you have to go through the whole thing again. We added the Amish schools.
It says 2 Amish schools.
2 Amish schools.
2 Amish schools.
Yeah. And again, I think didn't we pick up something also with the Issaquah Creek Watershed Management District? That wasn't there previously, and we picked that up.
Okay.
And again, we picked up the school district, Pioneer, Cuba, Rushford, Franklinville, and 2 Amish schoolhouses. I think we picked up the various fire companies too that provide various services. I don't know that was there. But again, local in nature, things like that you knew that wasn't particularly germane to the initial part 1. If you want to consider that, then I would ask you to think about this resolution. For the purpose of promoting effective and efficient use of the town's wind energy resources through wind energy conversion system, and to regulate the placement of such systems so that the public health, safety, and welfare will not be jeopardized, the town board proposes this wind energy facilities law, 239L, 239M of the general municipal law said law and all supporting documents are required to be submitted to the county planning board for their review. Whereas the town board has determined this type of action is a type 1 action under the State Environmental Quality Review Act. Town board for the town of Farmersville has completed parts 2 and 3 of the full environmental form and resubmitted a referral to the Cattaraugus County Planning Board on December 27, 2018 Planning Board meeting. Whereas the supervisor and the town board on January 4th received I don't know, want to say a letter, maybe a memo, that the Cattaraugus Planning Board is returning the referral to Farmersville as incomplete. We did not act on this referral due to the ambiguous answers in pages 2 and 3, part 1 of the full EAF form. Please clarify the information provided in C2, C3, and C4 and resubmit it for the county planning board. Whereas the town board has reviewed parts 1 of the full EAF and the planning board has form that the planning board had found to be ambiguous. Now on a motion of blank and seconded by blank, the town board of the town of Farmersville hereby authorizes the town supervisor of the town board to sign the revised part 1 of the full EAF form. That's what we're looking to do.
I'd like to make that motion that we pass that
Motion made by
resolution.
Richard,
I'm sorry.
I'll second it.
seconded by Pam. All in favor?
Aye.
Carried. You want me to sign this now?
Yeah, if you could sign like 2 or 3 of them, that'd be great.
Public comment that you had in mind there, was that regarding
Well,
Ginger?
she had made a comment, I know Mr. Spitzer,
Yeah.
both had asked to talk,
Well,
so.
we could
Can we,
put that in.
can I just finish this line
Okay.
of
Yep.
thought and we'll go on? Get my hands away from my face.
Okay.
It's tight this time of night too, because of my tie's down.
That's your tool, Dave.
Okay, thank you. If I could have one, you give one to Bridget, that'd be great. And then you can you give 2 to Bridget if you would.
I'm out of them now.
That's okay. Here, if you want.
I got Barry's, you don't need it.
Here's a couple more if you want to sign them, please. I guarantee you're not gonna stop hating me. Okay, this is a re-referral form pursuant to 239L. I go through the whole litany of what got us here, and basically, in accordance with 239L of General Municipal Law, and the Cattaraugus County Planning with Part 1 of the full EAF, in addition to all materials previously submitted. So we're re-referring it, so.
This is pretty much the same as the last one, correct?
Exactly the same.
Last 2?
Yeah, so if you wanna make a motion on that.
I'll make a motion on that.
Motion by Richard, second.
I'll second it.
Second by AJ, all in favor? Aye. Carried.
Hey, maybe next month we'll have something to talk about.
Yeah. There you go. You gotta do a roll call on that.
We gotta do roll call on the first one.
Yeah, we gotta do, oh, we didn't, did we do one? Oh, yeah.
I'll make sure I'm right. Okay. So the first resolution, I'll make sure I got my notes right. First resolution that Mr. Zink and Mrs. Tilton, made the motion, and second was to re-sign, right?
The revised Part 1.
Okay, that's what I got, okay. And the second was to resubmit to the county.
Right.
Correct.
Okay. Mrs. Tilton,
Yes.
Mr. Zink,
Yes.
Mr. Westfall,
Yes.
Mr. Warner,
Yes.
Mr. Karcher.
Yes.
Roll call for the second resolution. Mrs. Tilton.
Yes.
Mr. Zink.
Yes.
Mr. Westfall.
Yes.
Mr. Warner.
Yes.
Mr. Karcher.
Yes.
And as I indicated to you, Mark will be taking these to the county planning board for the county planning board
Okay.
meeting, and he will attend it.
Okay.
I've got additional resolutions there for you, if you need them.
Okay. Is that-
I also got other copies of the EAF.
Barry gave me his, so what do you need yours?
In case
or-
somebody asks.
Can we get another one on the EAF?
Okay, there's another one, that one's signed.
We'll get a signed one.
So that'll get you, in case you need copies, Bridget.
Okay. You all set, Rich?
Yep.
Dave, you have more, or? Okay, we had a request from Ginger to speak. You have time. Thank you.
Thank you for the opportunity to speak on behalf of formally over 300 of your constituents tonight. I just had a question whether or not any of you had a chance to read thoroughly the public record, both the testimony as well as everything in this binder. Has anyone had a chance to do that?
Been reading it. I don't know if I read it all, but
Well, I had a chance to do that, and I indexed it. So we've now had one informational meeting, one public hearing, and the results of the survey have come back. 195 for, 137 against, and 41 undecided. Rob, we saw your comment in the newspaper about it being even. And frankly, we don't know how you can take the group of undecideds and place them in the group of in favor of the project and then call it about even. That just doesn't really make sense to us.
I don't know if I said even, did I?
Yeah.
Well, that's what you read, but
So in any general poll, a closing lead of 15 percentage points is considered a landslide, and that's what this project opposition had from our perspective. We don't think that this record supports Invenergy's claims that the evidence is clearly in support of the project. 200-plus letters that were referenced by Invenergy in the newspaper, when you go through this record, they're form letters with many, many illegible scribbled signatures, many out-of-town construction workers, many duplicated records as well, people speaking 2 and 3 times on the issue. Letters with no signatures, no addresses. In all, giving the benefit of the doubt to a lot of them that I really shouldn't have given the benefit of the doubt to, 105 Farmersville residents stated support for the project. And of that, 46 of them have leases, so that's about half. The Farmersville population of 126 alone beats that. When you look at the total communication points from people in opposition to the project in this record, the total against was 211. That includes the Amish. So since Invenergy's counting on non-Farmersville people in this numbers game, I thought it's important that you know that last week the town of Franklinville retained us to represent their 3,000 residents. The board there is adamantly opposed to this project. They want to fight it all the way. Those are your actual neighbors, not out-of-town construction workers. You know, that's really, we're talking people that are right there being impacted by the project. We expect other local towns are going to join this week and next. So I think, from the perspective of Invenergy's claim in their application, that at least in this part of the town, in this corner of the world, their claim that there's vast community support for this project is just simply not true. It's just simply not true. In fact, they said for Farmersville, it's a small minority of people fighting this project, and I think that's false. So all of these people here tonight, at least a good portion of them, probably some of them are pro-project, and that's okay. We're calling on you to give us a stronger wind law. This includes what we've been asking for all along: 3,000-foot setbacks to property lines, 40 decibel, 24/7, 365 at the property lines. And since many people on the public record wrote favorably about the Eagle and Bliss wind turbines, said they weren't noisy, said they were less of an eyesore, but they don't kill birds or bats. We'd like ones like those too. What are they, 450 feet? That's what we would like. None of our members want to hear, but this will kill the project. And we certainly don't want to see the board again ask Invenergy, like it did at the last wind law session, are you okay with these changes? This is not a wind law for a specific project. Or is it? Invenergy does not care about any of us. They're just maximizing their profits. I understand that. That's what corporations do. I work for them too. Invenergy doesn't care about any of us, really. They're just out there doing what they do. The board doesn't have a constitutional duty to Invenergy, but you do have a constitutional duty to all of the people in this room. And putting in a reckless wind law is not fulfilling that duty to us. Well, you say, well, how is that reckless? Notably, Invenergy was just told by the New York State Siting Board in another project to perform evaluations of long-term potential cardiovascular impact and cardiovascular disease for a threshold of 50 dBA. Long-term in that parlance is 1 year. They were also asked to do an evaluation of conformance with the new 2018 sound recommendations, which is 45 dBA. Why is our proposed law over this? Why are we considering a level of dBAs that have yet to be studied for the health impacts? That deficiency letter should be in your mailboxes right about now. I think we'd like another work session, and we would like the residents to be actively involved in conveying to you our thought processes on these. And that's why you can see a lot of people here tonight showing up for this, because we're concerned about the direction that this is going in. And that's what we'd like to bring to you tonight.
Thank you.
Next one question. Early, about midway through your opening, you had the number 126.
Yeah.
Can you give me that back again?
Yeah, it's 126 Amish lives in Farmersville. That's the population.
Oh, is that what you said?
Amish.
Okay.
126 as of this
They're not
week.
against the windmills.
They are against the
They're
windmills.
against them on their own property, they're not against them.
No, actually, they're against the entire project, and I have a letter from them, and they've met with Invenergy and
Okay.
to their face.
Okay, Lois.
I just needed.
I represent them, Lois, so I think I have a good idea of what they think.
Is that a written submission that you're gonna submit that, or is that just?
Their letter was.
No, what you just went through. I mean, you said a lot. I think I would like to read it.
I can send it to you, I have some handwritten notes on it,
Perfect,
but.
if you could.
Yep.
I just,
We accept working copies.
yeah.
Okay.
Yeah.
The county planning board
If we
doesn't,
could.
but you do.
Okay.
Yep.
Thank you.
Okay, we had one more request to be on the agenda. Dan Spitzer.
Why do we have to listen to Invenergy again?
Because he was on the list to be on the
Why?
agenda.
Every time?
Every time?
We have to satisfy them?
He
Okay.
asked for permission to be on the agenda, just as Ginger did.
Thank you, Mr. Supervisor, members of the board. Appreciate your opportunity. A couple of comments briefly. It was interesting listening to the numbers game. I'm not your lawyer, I'm not gonna advise you, but I'm gonna tell you this. You may not make a decision based on how people voted in a survey. You may not make a decision based on what Invenergy said in an application. You may not make a decision on generalized public opposition or support. The New York Court of Appeals has said that, as have numerous other courts, again and again. And you're being set up for a civil rights lawsuit with this silliness over the numbers. Rather, as other folks have suggested, your obligation is to look out for the best interest of the community, exactly as you've done. Exactly as you're sending things back tonight to the county to get their input, to make a decision. Exactly as you held hearings to hear from people. That's your obligation. New York is a representative state. It is not like California, a state where everything goes to petition drives and things like that. And you cannot make a decision based on mob rule. It doesn't matter how many t-shirts you hear on one side here. It doesn't matter. Well, by the way, the t-shirt industry is what I want to get into in this town, as long as they're, of course, not making profits. You're doing things exactly correctly, which is that you haven't made a decision one way or the other, and you're listening to the public, and you're figuring out what to do. That's your job. That's what you were elected to do. It's not a matter of who voted how or who said what. It's what you believe is in the best interest of the community. I ask you to stay the course and continue to do exactly what you're doing. Thank you for your time.
We still have the responsibility for our health, safety, and welfare, and we still have the ability to limit the size, the scope, the distance, and everything else that we do.
Okay.
Article 10 doesn't say it has to be a 600-foot tall window, 1,800 feet from your house.
Okay. Anybody else have anything?
Yeah, I just wanted to.
Your name? Your name, sir?
Albert Brown.
Okay.
Albert Brown. I just want to say that, you know, I take offense to, this is democracy. You guys are, you're doing a great job. You're listening to the people are being respectful. And to have, you know, some snake salesman come in from Invenergy and call this
Okay.
mob rule. This is democracy in action. So I just take offense to that. I think that's ridiculous to say that. Just ridiculous. I mean, here we are, you have different opinions, we're hearing each other out, and we're trying to come to some kind of conclusion. But that's not mob rules, that's people telling you there's real feelings in this room. And I appreciate you for listening.
Okay, thank you. Kathy?
I have one thing I'd like to say.
Speak up,
I
Kathy.
didn't request in advance. But you also have the opportunity to give an airing to the public's opinions and desires for our future land uses. And we would like to determine what they are along with you folks, not a string of developers every 5, 10, 20 years. A big thing comes along and we all think we're covered. I was on the town board when we got a letter from Invenergy in 2013 or 15. I can't remember the year. But they said they wanted to build a wind farm. We sent them a copy of the law and said, please refer to this. They didn't stop. It's been 3 years now, and they haven't taken that word. So apparently nothing will stop them. So my suggestion, my request, and I'm circulating a petition that you folks consider a comprehensive plan, run it by the people, and a zoning ordinance or local law as it's determined after extensive public interaction.
Okay, thank you, Kathy. Hey, do you have anything else on this?
I don't.
Oh, Donna?
I really don't want to even make a statement tonight, because I'm trying to be as neutral as I can, and certainly my statement was made through the legislature when we voted to have the IDA not support the pilot program. But in our discussion there and so on, and with a couple of legislators, as we talked about it, it came out that whatever happens, it should go back to what the residents want. And I think, my opinion is, we got that with these postcards that came around and so on. This is what the residents want. Certainly there was a majority that stated their feelings and so on. So that's just how and like I say, I really wanted to make this statement, but.
Okay, we heard comments. Do you have anything else, Dave?
I don't. You have anything else of me?
When do we think the county planning board will meet again? Do we have any
They meet
idea?
the fourth Tuesday, and I know. Thursday? The Thursday?
Thursday.
And I know Mark's gonna be there, so that'll be the 27th, right?
Yes.
Yeah, I think all the
No, it's
dates
wrong.
are-
No, it's December, judges didn't change it.
24th. You gotta do that for me, right? I thought I was being so smart looking off. into the
Sorry,
distance.
not my room.
Okay. That's weird.
Okay. I'm sorry, one more question.
I just want to say that, in case that people here didn't know, the Statue of Liberty, if you took two of them, stood one on the head of the other one, that's what these things are in height,
Including the base.
including the base.
Two of
Two of them, right on top of each other.
To the torch.
I think the Statue of
That's
Liberty is
45
pretty
feet.
big.
Okay.
How would you like two of them?
Appreciate
one
that
on top of the
information.
other? And just so everybody knows how big these are.
Give you an idea, right? Thank you.
Okay.
Yep. Okay, we're gonna move on at this time to the regular board meeting.
I don't know if you need anything further from me, but.
Dave,
I'll get
you're all
it.
set. Thank you very much.
Thank you for your time. Thank you.
Have a good evening. Get home safe. At this time, I'd be looking for.
Thank you for providing us the time.
Okay, Dan. safe home. Any additions or corrections to the minutes?
No, I had nothing.
Okay, can I have a motion to accept?
I'll make a motion to accept AJ.
Motion by AJ. As you see in your letter from Kathy, there's no financial report. Everybody seen that?
Yep.
Okay, Bridget, you okay for the clerk report?
Okay,
Clerk's
death
report.
certificates, one of them at $10, conservation,
Can you
55
please
cents.
settle down, please? We're still having a meeting.
254.01, transfer tickets.